Welcome to Rappler Talk. I'm Marites Vitug, and joining us is a rare justice of the Supreme Court in his second TV interview, I think, for the year, Justice Marvic Leonen, and of course the former spokesperson of the Supreme Court, Duterte, who is now a faculty member of the UP College of Law and is also teaching at Ateneo Law School and De La Salle University College of Law, right? And joining also today is our ace reporter covering the judiciary, Leonen. We're going to talk about three issues, particularly. We hope to start with the selection of a new Chief Justice, which is the most timely issue. And this is the context in which we're having this interview today. So welcome, Justice Leonen. Welcome, Duterte.
Thank you.
And of course, thank you, Leon, for joining us. I think we'll start with this, the condition or situation of the Supreme Court today. You have just been through three historic events. First, the quo warranto, the ouster of Chief Justice Sereno. Second, we had the shortest ever term for a Chief Justice, 42 days. And third, we have an acting Chief Justice who's been there forever, the longest. And fourth, possibly, as you mentioned earlier, we may have a new Chief Justice before end of the year. So three, that makes three Chief Justices in the year. So how would you describe the court at this time?
Well, first, I think the court in the past few years have undergone a lot of major decisions. And I think many of them have been historical in the sense of their impact on contemporary politics. But I would say that the court is resilient, and that after the quo warranto, after or during the term of Chief Justice Tess de Castro, it has a bit normalized, in the sense that justices have worked collegially on a lot of the issues. There have been unanimous decisions. There have been decisions with dissents. There was, in fact, a rule that was just promulgated, this rule on precautionary whole departure, where although there was a dissent, the court has worked collegially on that particular issue.
So you were the lone dissent then, though?
Yes, on that specific issue. But the point is that the court has moved on, and I think it has adapted. The term of Chief Justice Tess de Castro has been, even though short, I think was instrumental in normalizing the relations within the court. And I would say that apart from restoring collegiality among the justices of the court, it has the Chief Justice, or the office of the Chief Justice, has regained the respect of a lot of the staff inside the court. And a lot of the policies have been restored, including appointments of chiefs of offices, among others, certain benefits that were owing to the staff, and the efficiency of decision making of the three top senior justices. So even though short, I think it has achieved quite a few things. By the way, there was also this ponencia that she promulgated on introducing for the first time the concept of sextortion. Sextortion, which is extortion on the basis of sex. I think this is a label that is that needs to be expounded in the future.
So are you in the court awaiting a new Chief Justice, or isn't this a big deal?
Well, of course,
everything seems now to have subsided, yes, normal.
Yes, I think the position of Chief Justice is much awaited. Who will be actually appointed is also much awaited. But I think what has been restored is the Chief Justice is one vote in terms of the items on the agenda, but matters in terms of the leadership of the court, where we are headed to, and of course in terms of the administration of the entire judiciary. So we are awaiting, although of course because it is justice Antonio Carpio, who is the Senior Associate Justice. He is an old hand. He has a lot of gravitas. He is respected in terms of his intellectual ability. He has experienced a lot in terms of the court and in terms of politics. There is a lot of confidence in terms of how the court is managed, even though he is an acting Chief Justice.
Sir, would you say na, kasi diba 5 yung nag-a-apply na justice, would you say na the Supreme Court would be okay with any one of the senior justice, or baka magkaroon ng issue if it's not the most senior, who is Carpio?
Siguro balikan natin yung seniority, no? To me, it is a marker of experience. It is a marker of, I think, a period under which you have gained the respect of your colleagues. So, I think part of the lessons that we can learn from the past is it is difficult to get somebody who is junior to the court because sa totoo lang, it took me about maybe 2-3 years to actually know the procedures, the traditions, and in 2 or 3 years, you are introducing yourself to your colleagues, and it's very difficult to pluck someone from the most junior ranks and put them into the leadership position. You have to have experience as chair of a committee, because in committees, you are able to deal with lower courts and with other staff. I think it matters that you have held, even in an acting capacity, a division, because that's where the adjudication happens. So seniority is important only because it is a marker of experience and potentially leadership. So among the 5, of course, each one have their peculiar abilities. Justice Antonio Carpio, as I said, as the gravitas, and easily, I think among all of us, he would be the most logical choice, because he has been in the court for a long time. He has been bypassed a lot of times. But at times that he acts as acting Chief Justice, decisions are efficient. Decisions of other justices are respected. There is there's good facilitation of the discussions and bank. So is the easy logical choice. Justice Dado Peralta, who is next senior, is very passionate about the efficiency of the court. So you've seen him work on continuous trial, speedy trial. He's very knowledgeable on procedure, knowledgeable about the staffing of the court, knows a lot of the judges and the justices of appellate courts. Justice Luke Bersamin, on the other hand, is very diligent, very conscientious in terms of his decisions, has expertise on and also procedural law, on judging, on experience in the lower courts, etc. He has an eye to detail, and I've seen him call my attention on things like the particulars of a penalty. I forget the 1 day in terms of the minimum or the maximum. He will call my attention on that. I forget exemplary. I forget Hugueta, People versus Hugueta. He'll call my attention, so detailed. The other one is Justice Stella Bernabe, Perles Bernabe. Well, she also has the respect of the staff and the lower courts. She is very collegial in terms of her work. She stands on a lot of the doctrines that she has promulgated. And in many cases, most of her ponentias are unanimous, simply because she is able to accommodate as much as possible the other points of view. And I think that also is a mark of a good leader. So I would say that those are the things that the court looks forward to.
Isn't there one more justice aspiring to be Chief Justice?
No. Yes.
Justice Andy Reyes.
Justice Andy Reyes is not part of the 5. He has been in the court for less than 2 years. And although he has been presiding justice of the Court of Appeals, there is actually a difference in the management of an appellate court as vis-a-vis the management of the highest court of the land. Justice Andy Reyes has a lot of talent and skill, but I think that we should not repeat what has happened in the past, and we should look at the top 5 of the justices. There was one more. This is Justice Mar del Castillo.
Castillo.
Of course, I was disheartened that he had to decline. He chose to decline. Justice Mar del Castillo, I would say hands down, is the most compassionate among all of us. And I would even say the kindest among all of us. He would sit down to listen quietly. And when he comes out with his ponencia, it's full of grit, full of depth. But for his own reasons, I think he declined, and I think he will be the acting presiding officer of the Judicial and Bar Council.
Yeah.
So you mentioned JBC. I would like to bring inserted to this yung latest announcement from the JBC and the ANBank. No more public interviews for the senior justices applying for the Chief Justice. Sir, how do you feel na, di ba sabi niyo nga ito yung pinaglaban niyo dati sa flag?
Well, yeah, historically, I think it was flag that first brought up the public interview requirement. It was during the time of Ombudsman Desierto, when he was applying for ombudsman. And because Flag had a bad experience with him during one case, Flag said we wanted to listen into the interview. And so we made a request to the court at that time. I think it was Chief Justice Davide, who was the Chief Justice at that time, for the interview to be made public. And the court allowed it. And I think thereafter, it was integrated to the JBC rules.
So are you disappointed now that we're not?
I haven't read the resolution. I have only seen what the media has reported.
Yes. Maybe just to clarify, it's the JBC that makes its own rules, and the JBC is comprised of or presided by the Chief Justice.
Yeah.
And I think what the Supreme Court did unanimously was expressed the sense of the court, and the sense of the court was, of course, also reacting to the past interviews for Chief Justice. And I think the point of view of the court there was the public and the JBC for the position of Chief Justice only. I think the public interview for everybody else is still there. But for the Chief Justice, maybe the court was wanting the Judicial and Bar Council to look at the body of work. And the body of work of a senior associate justice is in the decisions and in the way that they have managed committees and the divisions that they are in charge of. And the body of work is important because it is where you will see the judicial philosophy. If you read hard enough, you would see the level of analysis that a senior associate justice would put into their work. I think the Court and Bank was disappointed that there were questions which, well, truth to say, were not proper, and they catered to something they catered to trivia, and would deter from focusing on what should matter in terms of the Chief Justice. So that was the sense of the court.
Yeah, speaking of the JBC, that also reflects on the quality then of the people there if they resort to Miss Universe type of questions. So are you in favor still of the JBC as a body that will vet applicants to the judiciary, or do you have thoughts of how this could be reformed?
Maybe we could also connect that with the decision of the court in Hardeleza, where the court basically required the JBC to amend some of its rules.
Yes. Just to correct the impression, I am not criticizing the JBC. The Judicial and Bar Council is doing its best, and I think has done a good job. I'm just criticizing a few of the questions that were asked during the time of the selection for the past Chief Justice. But and I know all of them. They are hard workers. You can imagine how it is to interview thousands of applicants for a lot of positions that are open. And of course, the pressure that they are in whenever they are to vet the candidates for the position. But the Judicial and Bar Council, I think, is designed to be malleable to the public because the representation there is very clear in the Constitution. You have a private sector representative, you have a member from the academe, you have a member from the legal profession, you have a retired justice that sits there, and then the ex officio, the DOJ representative, the Chief Justice, of course, and I think
Congress.
Chairman of the
The Congress.
the chair of the Congress, subject to the opinion of the court in Chavez,
Chavez.
which I lost. Chavez versus
Where he
JBC.
dissented.
My point was, there has to be a congressman and a senator, but
Right.
the Supreme Court said that the Constitution requires only
Only
one.
one,
But that's not the topic that we have. I can speak volumes on that case.
Please don't.
Justice, if the problem or the concern of the court and bank was that some of the questions you didn't find it proper, couldn't have there been a dialogue na lang between the JBC and the ANBAC na parang sana ganito na lang yung mga tanongin natin rather than just take away the public interviews?
You know,
entirely?
the Supreme Court is an institution in itself, and it can only do as much as what it is designed to do. The Supreme Court does not speak to the JBC, does consultation with it, because we are, in a sense, on a supervisory role, JBC versus Ardelesa.
Right.
So there are situations, Aguinaldo versus JBC, where cases will go up to the court. All we could do is express our sense and instruct the Chief Justice or give guidance to the Chief Justice who will sit in that body. The same way that we do a straw vote for the candidates to be vetted for the Supreme Court. It's just advisory to the court. Now, it is up to the Judicial and Bar Council to decide how it goes about its task. There is a fundamental difference between what we had in the 73 and 35 and this system. This system has a lot of merit in the sense that it involves all the sectors. But on the other hand, under the old system, a president could actually envision a court and then look at what should be represented in the court, search for a nominee, and then present it for vetting. Okay, now, under the present circumstance, it is passive. In other words, the JBC, although it can if it wants to, but the JBC now waits for an applicant. And with the applicants, it has to make do with the list. My reading of the Constitution, however, is the Judicial and Bar Council is not a passive institution like a court, but it is a search committee.
Yeah.
So it can envision a court, put a civilist there, put a constitutionalist there, balance career judges with the academe, with the practitioners, etc. Look at what is needed out there. If we are entering into an era where there's a lot of transnational litigation that's happening, transnational issues, cross-boundary issues, then perhaps we can look for somebody who is knowledgeable in international law as it affects domestic law. So that's the difference. Now, the other advantage of the JBC now is there's a private sector representative. And that private sector representative can be business, or it can be
There's no,
an NGO, yes.
There is no requirement that he or she should be a lawyer, right?
None.
For the
No,
private
no,
sector.
no.
None.
So why are they all lawyers?
Again, that's the other engagement that the public has to do.
Yeah.
I would say civil society and the public should engage in many ways. Of course, depends on the sector within civil society. I think we should start thinking of civil society as not one amorphous, atomistic set of individuals, but of sectors and pressure groups. So there should be insistence by the academe that the representative should be a member of the academe, and there should be qualifications created by the academe. For example, would you require a tenured professor? Would you require a person that has written on the court? Because that's the academic way. Or the private sector insisting that it must be someone that has a business or whatever. Okay, but I leave that to the various sectors. But the Constitution has been designed in such a way that you have those representatives. I know, for example, that the Retired Justices Association do say or do recommend a name.
Yes.
Okay, in order that that person be considered by the President when it appoints, and by the Commission on Appointments when it vets the nominee of the President. So that's, I think, one very important engagement that the public must do, because there's a lot of consequences in terms of who are appointed to the judiciary. I'm not speaking of the Supreme Court only. I'm speaking of the appellate courts and the lower courts.
So, very interesting, Justice, and really enlightening that you talked about more a visionary kind of JBC, that they look at the composition of the court, look at the mix, I'm talking of the Supreme Court, and then do an active search. So this is what's missing now.
I would say that that's a possibility. But the other one is, well, that's an intuitive kind of approach. Okay, the other one is more empirical. So you wait until those that are interested will apply, and then you have sort of, you talk about a criteria. But of course, you have to have a collective body that's given direction. And when there are different people that are in the JBC for the coming from different sectors, it will take time for that body to reflect. And then the other thing is, of course, the JBC is inundated by vacancies.
Yes.
And, you know, it has done its work. It has done short lists and have given it to Malacanang. And it has tried to reduce the number of vacancies without short lists. And, well, to do that daily grind and then to have a vision for the next Chief Justice and the Supreme Court will take a lot of work from that specific group.
In the previous vacancies, the court has submitted its sense of who it wants the president to appoint.
Yes.
Do you intend to do that for the Chief Justice vacancy? Because the short lists, the recommendations of the court in previous occasions have actually resulted in the people being appointed.
Well,
Justice Martirez as ombudsman, for example.
Yes.
So,
well, it's a tradition. And I think in the terms of looking at it from a larger perspective, it is the court saying this is who we need, or this is the kind of person that we need, or this is the person that will be acceptable to us, not necessarily because it will concur with all our decisions, but because we need this. Okay, but that's one input. The other input should be we have to monitor the court, and we have to guard against certain decisions that the public says would not be the kind of decisions that they want the court to do, which is the second engagement of the public. So apart from actively involving itself in the selection process via the representatives and with each and every candidate, specifically at certain levels, the other would be that the public looks at the decisions and understands what the court is. And this has been my observation. The public sees the court as if it were a Senate. And therefore, it looks at the result. And if the result is not of the right political color, with whatever color they give to a judge or a justice, then the judge or the justice is criticized for it. So for example, you acquit somebody, and the public comes out and says, why did you acquit that person? Nabayaran ka ba? Okay, without looking at the content. You should not look at the court as if it were a political body. You should look at the court in the way that it reads the law, and the consequences should follow. Because otherwise, you will be encouraging judges to look at the result first before they look at the law and the logic of the principle behind the law. What you want the court to do would be, well, to the public to say, this is a good decision because this is the law. Dura lex sed lex, fiat justitia, ruat caelum. Okay, do justice, though the heavens may fall. Okay, and the interpretative principle that this judge or justice did is something that is very reasonable and napapanahon under the contemporary situation is called for, or social justice is required under this interpretation. So again, the public tends to look at the court as if it were looking at behavior of politicians. And we should not be encouraged to do that. And the way that we are encouraged to do that is when trolls come out and then start attacking justices. Although I can say for a fact, you know, having been in the court for close to 6 years now, the court has disciplined itself, or my colleagues and I have disciplined ourselves not to be too affected by the drama that's out there. Maglagay kayo ng kabaong lagyan nyo yung mukha namin doon sa kabaong, it will be looked at as a trivial thing. But criticize us in terms of a law journal article and a well-written, report in the media, well-written, with all the nuances there as much as possible, given the space, okay, then we will be more responsive to that. But I think just carrying a banner out there, etc., wouldn't affect the court. Again, look at the court not as a political body. Do not train it to become a political body. Make it a judicial arbiter.
You know, the social weather surveys or Pulse Asia or both, when they do ratings of institutions, the Supreme Court's always among the lowest, but the majority or plurality say that they don't know, they don't understand the court.
It's maybe because they're just ambivalent about it. It's not just that they don't like the Supreme Court.
Yeah, they don't know what's really the function of the court. They don't know what's happening. So how do we...
I think that's good. I think that the court is not well-liked is good, because you will have to decide against somebody and in favor of someone. You will have to decide for or against a corporation, for or against a labor union, an NGO, etc. And in your lifetime as a judge or a justice, in your lifetime as a court, there will be people that will be favored sometimes and not favored sometimes. So in the end, by definition, you are not popular.
Correct.
So when you retire as a justice, the best justice retires with unpopularity. But that means that you have to insulate the court from the politics of it and insulate the court from all the burdens and the favors coming from the politics that is happening out there. So to me, that social weather station survey or the Pulse Asia survey or whatever survey, one, we should not concern ourselves with that, or the public shouldn't care. Okay. Second, might indicate something good. The court is not popular at that time. Maybe next time it will be popular. So again, I think the role of a judge is not to be popular. The role of a judge is to do what is right given a norm that was promulgated correctly, and that is the law.
One thing I did mention before to, I think, Mahar Mangahas was, maybe one question they should ask is, have you read a decision of the court and did you understand it? Because I think the burden of the court is really to make itself understood and not necessarily popular. As long as they're correct, then the court has carried its burden. So if they surveyed people, which Supreme Court decision have you read and did you understand the decision? Not necessarily whether they agreed with it, because that's what would carry the popularity. If they understood it, then it means the court has done its job.
But that's not been included yet. No?
I don't think they include it because, again, people are probably ambivalent about the courts because it's not, there's no instant gratification as far as the court is concerned. It takes a long time for decisions to come out.
Why should the Chief Justice be rated in the same way as a House
Yes,
Speaker?
that's exactly
I don't think that should be, that should matter, right?
It shouldn't.
The structure of a decision, and Ted is correct. In the structure of the decision, the value is the smallest portion. That's wherefore the accused shall serve a sentence off, or the decision is affirmed and the accused shall serve a sentence off. That's one sentence.
Correct.
But the bulk of the decision, the bulk of the number of pages that it has, is really an explanation. And the factual ambience, the environment, the issues that have been spotted, the law that is applicable, the interpretation of the law, the precedents that were used. Okay, that should be read. Now, I understand that the public will not have time. That's why we have to deal with, again, there are, in my point of view now, there are three institutions that are very important to maintain truth. And that the first one is courts. Of course, I'm there. Second one is you, media. The third one is the academe. And if courts, lower courts, do not follow precedents, then we have a problem. If lower courts are free to just follow their own doctrines, then we have a problem, especially the canonical doctrines. There are doctrines that need to be overturned because they are no longer fit for contemporary circumstances and do not apply social justice. But in the ordinary run of things, lower court should follow. Second is media. if media does not do its job of validating information, of analyzing, then it serves a negative purpose, which is to reify, to repeat something that is false and a misinterpretation. I have seen Twitter feeds citing a newspaper report, citing a wrong interpretation, another Twitter feed of a particular decision. And I can name to you the cases, but I will not. But yung mga ganon. But I also know of Twitter feeds by responsible journalists who will attempt to actually correct,
Yes.
but at the same time do its job, to try to reduce into 280 characters, something that has been promulgated, but, well, exact. Of course, caricaturized, but necessary in order to entice curiosity, etc. The last one, and I think this is sorely missing, and I'm sorry, I came from the academe, but there needs to be a strong push coming from legal academics to actually assist in the interpretation of certain decisions and not play the role of popular politics. They should read the cases and explain it carefully. For example, the recent decisions of lower courts in terms of controversial cases or the Supreme Court in controversial cases. But sadly, again, as I watch, there are a lot of legal academics that are already partisan at the get-go and then try to explain a particular case from the point of view of a partisan. I don't think that's the role of the academician. I think the role of the academician is to explain.
Yes, that's where you come in, Ted, because we will rely on you and your colleagues even to help journalists interpret. Leon,
that's what we hope to do.
Try to get hold, and that's our frustration also, is that some legal academics don't want to explain or comment because they are afraid they might offend the Supreme Court or some judges. Yeah.
Well, that's true. I've spoken to some of my colleagues, and that's one is there are academics who are really caught up in that academic world, and they really don't want to bother with these things. That's one. On the other extreme, there are academics who will volunteer, practically, feed themselves to media. Then you have the middle ground, which is where a lot of people are, where I think they're waiting for an opportunity to write, to comment, and to maybe say something, and hopefully, if the right people are tapped, then what Justice Leonen is saying can happen. The education can happen. Something that we hope to do when I was in the PIO, but we had some degree of success, but not a lot. So yeah.
Just wanted to, sorry, I have to bring this back to the public interview, sir, because you said kanina there's value in dissecting the decision and not just the result, but there's really not a lot of avenue for the common Filipino to dissect a decision, and I think a public interview for a Chief Justice would have been a good opportunity for the JBC member to discuss the potential or the opinion of the Chief Justice applicant, but we're not going to see that now for this.
The decisions are out there, so it's always uploaded by the PIO. It's not promulgated unless it is uploaded and served on the parties, and the upload comes before actually service. Justices of the Supreme Court are very careful about the formulation that they put into our decisions, because we know it is not only for today, although it will not be covered by the media. It will be researched in the future, etc. Abrams versus U.S., where Justice Oliver Wendell Holmes dissented, is still one of the heavily quoted.
Yes.
But Wendell Holmes, 2 months before, was the ponente of Schenck versus U.S., where he ruled differently. And to this day, I guess he has, or his family, or his legacy has to live that down. For 2 months, he came out with inconsistent decisions in the area of freedom of speech. Yes. So the point there is we are very concerned about that. Okay. The other thing I recall, criticisms of justices. The reaction is we might offend them. We might offend them. our culture on a daily basis is actually to give reflections to each other. When we deliberate with full frankness and candidness. Okay, and of course, sometimes there are emotions, but it's very rare. Usually, somebody can point me out and say, you forgot that this is this and that, or this is the doctrine that as I understand it, etc. So we are used to our being called out, sometimes rightly, sometimes wrongly. And the measure of a good justice is that they are open. And of course, that they hang on to principle for so long as it's the correct principle. Okay. The public's idea that they will offend a justice and therefore baka sa susunod na kaso matatalo ako, never seen it happen. Never seen it happen. And itong party na to maingay sa public. Therefore, in this case, ganito dapat yung aking resolution. That's not the kind of justice that you want. And the truth is that it is tempered by the collegiality of the court. So I would say to people who would want to criticize, just go ahead, write an article about this person. I have been called stupid and an idiot. Okay, on
Twitter.
I know who did that.
On a column, and then replicated in Twitter all over again. There is a weekly column that when I read it, I know that it's going to be negative. Okay, so I read that.
There are. You should tell us that later.
On the other hand, my other colleagues also know that if you read this, I just want to know what this person is saying. I want to read Rappler because I am sure etong sasabihin nila, and lo and behold, surprisingly, ibang sasabihin, and so on and so forth. So we are used to that. So, but on the other hand, we do not want to be told, mali yung provision mo, mali ang sinight mo. Okay, then the following decision, we would be more guarded, we will be more conscientious, and we would do more research on that particular point of law.
Now, I'd like to discuss now the number of justices who will be appointed by President Duterte. By the time he steps down in 2022, Lian, you said he would...
Only you, Justice Caguioa, and now Justice Reyes and Hernando. Ano?
And Hesmundo.
No, only Justices Caguioa and Leonen are not Duterte appointees.
Right.
By the
two of
time
them.
he steps down.
Correct.
So he would have appointed 13.
Yes.
Does that bother you that, this 13 will all be appointed by a single president?
Not the number. What will bother me is, of course, the vetting. But I must tell you my history. I was appointed by Pinoy, and contrary to popular belief, I have decided I have voted on certain controversial cases within the first 2 months of my appointment against the president. You remember Gonzales versus Executive Secretary? I tendered the deciding vote, which is the president may not remove a deputy ombudsman. That was on motion for reconsideration. They were waiting for me because it was 7-7. And when I sat to look at the case, sadly, I said, the president cannot remove a deputy ombudsman due to separation of powers as a canonical doctrine. Okay? DAP, I voted against the president and many others. The president that appointed me. So, I am not as concerned about the number. I am more concerned about who is going to be selected in order to sit down. And I trust, again, as I said, the wrong thing to do when you're in the court or when you deal with the Supreme Court is to immediately color the motive. Okay, you look at behavior because that's what we are trained to do. You look at facts, then later on you speculate on why that is happening. Okay, and well, that's it. I'm concerned about the mix of the people in the court. I am concerned about the identities that are represented. And in Re Valenciano, I have a dissent. I am concerned about the impact of religion in terms of the court. So those are my main concerns.
What should be the ideal mix in your view? From the academe, career, jurists?
Yes. Luckily, I don't have to execute that because I'm not the president. But I would just say this. A municipal trial court judge will have to deal with a finite number of issues presented to the MTC. When he or she goes up to the regional trial court, a finite issue, Court of Appeal, Supreme Court. There are the usual cases that go to courts. Marginally, there will be a constitutional issue, etc. Academics look at the world from a different point of view.
Right.
They look at it from a greater point of view. For example, a trial court judge, you do not expect the trial court judge to have read, let us say, Buenaventura de Santos Sousa, okay, a postmodern thinker, or Duncan Kennedy. You don't expect that. Or read X number of law journal articles. On the other hand, an academic coming in will have to deal with issues like what happened in treachery, murder, the usual run-of-the-mill cases. I came in with a specific field, human rights, legal aid, public interest law, and that's very unique. But of course, there is the extrajudicial foreclosure, and that you will have to deal with. So you have to balance that off. Judges come in with standpoints and assumptions, and prejudices and bias, which they have to tone down. Okay, and therefore, a woman's point of view is intrinsically different because of the journey that that woman has gone through in terms of her career. Okay, so will a LGBTQ person, anyone who identifies herself with that. So with a person who belongs to what is now known as the Bangsamoro, for that matter. Okay, so that would be the field. Now, I think a serious choice by a president would look at what do we have now in terms of the court? What do we have now in terms of the applicants? And therefore, to try to match that. And that would be a very good legacy.
The appointments so far that President Duterte has made have been career jurists from either the Court of Appeals or the Sandigan Bayan. With the last appointment, Justice Hernando, coming from the Sandigan Bayan. And so far, have all been men of a certain age, with the exception of Justice Hernando, and maybe even, well, not Justice Hernando is the one 52 years old, and all the rest were above, I think, 55.
Above
Yes.
60.
No, Justice Esmundo is on the younger
Okay,
side.
yes.
But won't that, well, deter certain applicants from saying, why should I aspire? It looks like he's looking for 13 career jurists of a certain gender, of a certain make, right? So how would a prospective applicant, for example, who would aspire for the justice, say, okay, I'll toss my hat into the ring?
Like Dean Villanueva, who have been bypassed.
Dean Villanueva has applied so
There's
many
only
times.
one female justice now.
Right now,
on
it
the
will
court.
it is Justice Bernabe who's the only female justice left in the court.
Well, that's a president's choice.
Right.
But maybe just to address not the president's choice, but the attitude of applicants. And in law, we have a rule in evidence that past action is
They're
not
not
a proof.
defined, yeah.
Yes, it's not a proof
Right.
of what has happened.
Correct.
Okay, unless you want to prove habit. Okay, but the truth is that who knows how the president is thinking. So I would, if I were, for example, an academe wanting to join the court, if I were a practitioner that has done everything that he or she has done in terms of practice and wants to join the Supreme Court immediately, has that seniority and so on and so forth, well, they should have the courage to apply. You have to provide choices to the president. You have to provide options. And as I always say, inertia and oppression happens whenever at the starting point, we accept that we are defeated. Okay, I've heard it many times before. Bakit naman kami mag-monitor ng Judicial and Bar Council? Kasi si President naman mag-a-appoint and magkaiba kami ng political party and so on and so forth. And my point there is, you are already defeating yourself by a projection of the future and an understanding of the past without focusing on the present. Ayaw na namin mag-lobby dyan sa Senate kasi wala namang kaming pag-asa. You already shot yourself on the foot. And the only way that we can move forward for reform or significant change or structural change is when somebody has the courage to actually come forward and put up his name. And at great risk. People have applied for more than 8 times, 9 times to the Supreme Court.
Yes.
Okay, and I shouldn't be disheartened easily. You're tested. Because when you get to the court, you may want to believe that this is how the case should be decided, but at the end of the day, it's 14-1. And you have to have the attitude of accepting that result, respecting the majority, but still knowing deep down inside that you are right, except that you have to implement the 14 votes.
So it's interesting you mentioned not accepting defeat. Yan ba yung attitude mo kasi you're the usual dissent?
Yes.
And paano yun, Justice, na parang you're the usual dissent, laging on the losing side yung boto? I mean, how do you...
The most number of dissents and separate opinions
Has
in,
been
by
by-
2017 for the past 2 years in the annual report of the court.
Oh my God.
Yes.
Nagbibiroan ba kayo doon, Justice, sa ANBAC na parang...
Yeah, you know, we are human beings, and because we work together over lunch, over breakfast, we kid each other, and some can be funny. Okay, most are funny. There are people that really break the ice. Justice Dado, for example, is very skillful in terms of the use of humor whenever there is something that is tense, and that helps in the facilitation of some discussion. There are some more serious than others. Okay, I view my dissent as maybe because I come from a different background. Maybe it's because among all the justices, my journey was public interest law, and I've also come from the academe, and unlike the others that also taught, I was tenured in the academe. I was also dean of a college of law. So my point of view might be a bit different than them. My clientele was indigenous groups, and I have climbed mountains, walked through fields, I think with more hours than any of my colleagues. But on the other hand, some have dealt with very large commercial contracts in their past. Some have served from the lowest, became court attorney, then prosecutor, then MTC, then RTC, then Court of Appeals, then Supreme Court. That's a different journey. But it so happens that my point of view might not be for its time. So I just settle with my dissents. But to be truthful, I think the court has unanimity in, let's say, 90% of its cases. Unanimity at the en banc or the division level. The only reason why some cases are highlighted is because there is a dissent. Yeah. And sometimes these are, in my case, the cases which are very close to my heart in terms of the interpretation that should be of some of the provisions of the law.
So you're not lonely. I mean, always being at the center, it's not a frustrating thing for you.
It is not. Although you do not want to be in the dissent. You would want to be in the majority, and that's very natural.
What's your favorite dissent?
Yes, good. Yes, sir. What is your favorite dissent?
All of it. Because that I had the opportunity to write it, and then I have the opportunity to put it on paper, and it's now part of my body of work. Now, in the future, I just hope that some other justice can pick it up when I'm no longer with the court, or when I am a bit more senior, I can convince the others, I do not know if that will happen, that we hew closer to the interpretation that I have proposed. Again, some of the interpretation that I'm proposing are not actually new.
Yes.
In my point of view, it is very traditional sometimes. But the others would say you have to be a bit more progressive in terms of your thinking, etc. Yeah.
Sir, nagkakatampuhan ba kapag when you finally publish your dissent and medyo scathing yung mga words mo against the member in charge? I mean, has there been incidents
Ito nga
like
hindi ko maintindihan. Kung minsan there is a personalization of the drama when it comes out to media, but actually inside, we dine together. We still speak with each other. can imagine any given day where we deliberate that there are hundreds of items in the agenda. On one agenda item, I am with Justice X. On another agenda item, we are debating with each other. On another agenda item, it is the two of us versus the other 13. So you get used to that. It's not about us. It is not about you. That's how it's not about me. It's about the person in the case. It's about the person about to be in prison, about to be given liberty. It's about the corporation being rehabilitated. The boy that was raped, it was about this person that was cruelly hit by the parents, and so on and so forth. So it is about how we are going to interpret Article 266B in relation to Republic Act 7610 in terms of lascivious conduct and rape by sexual assault. It's about whether or not acts of lasciviousness still exists, because there's already a new law, and that is 7610, and that new law on rape, which forgot to transfer one of the provisions.
So I think that's well and good, but there's also an aspect when in vetting justices na kailangan din makita yung track record, paper trail in terms of may integrity ba yan, hindi ba yan corrupt. So I think the JBC is just starting to have an investigating arm, no? Parang my understanding is they're just hiring or putting up this unit to do investigation. So how can the maybe civil society or how can the justices help? Or maybe you're too much of a burden for you. Paano kaya malalaman pa ng JBC kung ano yung mga kailangan malaman about certain candidates or applicants?
I think that's where the JBC is doing very well. It has its own investigators. It goes through the track record of from properties to bank accounts to past decisions. And it depends on each JBC member which one they want to focus on. And I thought this was seen also during the questioning. But the sad thing is, a JBC member asks, and sometimes media does not develop it. And sometimes, Rappler is the lonesome in terms of developing a certain line of question. And I think media and the public has to follow through more often than not.
Sir, who would you say in the JBC yung pinakagusto mong magtanong?
Sila lahat. Para sigurado. Well, all of them have their own, each member of the JBC, member of the court, they have their own styles. And you see this in oral arguments, di ba? The way that we ask questions, the area that we want to develop. And once in a while, you will see that this person wants to focus on procedure, etc.
So I think we have time for a few more questions. Do we have questions from social media?
Sir, siguro ito yung mga fan nyo on Twitter na nagtatanong, how do I survive law school daw?
Hala.
You survive law school as you survive anything. And I think the most important thing to remember in law school is that you are doing it not because of yourself. That's why in the bar exam, I am really against a top 10. Because to me, it is all about you. And to me, I would like that perhaps in some future time, it is going to be a pass or fail. Gusto nyo may high pass. Okay? Pass or fail. Because what you want to know is whether you're qualified, but what you do not want to know is I am better than all the rest at this first stage when you just took an exam. So it's not about you. So my advice to a law student is what I tweeted one day, which is when you're feeling lethargic, think about the person that you're able to assist. Can you imagine? You are a simple individual, but with your piece of paper and the knowledge that you put in your piece of paper, you can move the state system for or against a certain person. And it's the skill that you develop at the time that you are studying. You are too focused on how many times will I read a law book before you actually understand that is what your role is.
By the way, why are you on Twitter? Why not Facebook?
He was on Facebook before.
Yes, I was on Facebook.
You deserted us.
I deactivated it and
When he became a justice.
Yes, attempted to delete it on November 13, 2012, because I felt that Facebook was too uncontrolled, and Twitter used to be 120,
140.
140. Now it is
But
280.
You're the only justice of the court, no? Who's
Justice
on
Tony.
Twitter.
Justice Tony.
Is on Twitter?
That you
Yes.
know.
Oh,
The
see,
other,
that's
Justice Carpio on Twitter?
Yeah, Justice Tony is
yes,
on Twitter.
the others may be monitoring. I do
Yeah.
not know. They understand the technology involved. I have seen many justices use their computers and their cell phones. We are issued cell phones in order for us to communicate with each other. Some of us communicate through the latest messaging app. I will not tell you, but for you to be informed. Very rare that we cannot contact each other directly through our cell phones. But you know, gone are the days that justices should simply be in Mount Olympus. I think because we have gone to the court through a specific journey, so a specific trail, we have to understand the other world and try to engage with the public without deserting the ethics of our role. So in Facebook, you cannot comment on any case, any pending or future case. So I think you would see I post poems or advice to law students. Once in a while, I will post a newspaper article. I would, advocate plant-based whole food diet and so on and so forth. Or for that matter, I posted something about a pageant where the question was very deep. I cannot even answer. Okay. Then you engage by going to places. I've been to Tawi-Tawi where I discovered that the increase in the docket is something good because the residents understood that there was now a regular judge. They started having confidence. That's how I learned about that, and I went back and I convinced my colleagues to create a committee for underserved areas, which I now head. Justice Dado, for example, goes around the country. So does Justice Tony Carpio. Justice Bernabe also takes time to speak with lower court judges. So Twitter is just one mechanism, and I think that is important. But the thing is that you have to understand that there are ethics of our profession that we cannot breach. So I've had instances where people ask me a legal opinion. I have not responded. There was a law student that asked me an answer to a homework. I responded and said, hindi ko sasagutin yan, mag-research ka.
Kilala ko yung prof mo.
He's also on Instagram.
Yes.
You post photos?
Yes,
Yeah.
I post photos.
Yes, he posted. And I wonder paano nyo yung kinukuhanan, sir. Do you go out of your car? Kasi street siya, parang
Yes.
sa
Well,
lansangan ng mga picture ni...
That's one of the things that I would want to do more, which is to engage in photography. But, well,
How about
there's a
photos of the
cell phone.
court?
No.
Hindi pwede. PIO lang gumagawa nun.
But maybe as a future thing to do, I will get the portraits of the justices. But
Yes, anyway, that's not unethical, right? To have
No,
portraits.
as long as they agree, then no problem.
so long as they agree.
And
But
what I think
I
is-
don't think they trust me enough.
What I think you can't do is take your photos in session in the
Yes, during the conference, yes.
There
That's right.
are traditions which assist in the deliberation. For example, that only the 15 of us are in the deliberation room.
It's
Helps in
up
the
till today.
up till
Yes.
today, helps in the candidness of the discussion. That what is discussed should not be public, should not leak out to the public is still, I think, the general rule in order to facilitate the deliberation.
Justice, pahabol na isang question from Twitter. Have you considered running for an elected post?
No, never,
Simple answer, no, never.
never, because that's not my medium.
Oh, that's for Twitter, exactly lang characters.
No, never.
Yes.
Right.
I think on that note, we'll conclude this interview. And what we've seen now and we've listened to is a very rare glimpse, actually, in today's into today's Supreme Court about justices now on social media, about giving a rare interview like this. And now we also have the opportunity to talk to a former insider who's developed great insights on the Supreme Court. So we hope that we will maintain this engagement, and we also hope the public can keep an abiding interest in the court, because it's not like the Senate, it's not like the executive, it's not like Congress, wherein we can just go and watch deliberations. It's here we have to do more our homework, read the decisions that you upload,
Yes.
understand the legalese, and this is one of the efforts of Rappler at understanding the Supreme Court. Thank you very much, and please join us in future episodes of Rappler Talk.